Your spouse's I-130 finally got approved. You're quitting jobs, selling furniture, and booking a one-way ticket. Then a single notice arrives, a letter from USCIS stating that they are revoking the I-130 petition that you just got approved. And now, because of the Supreme Court's Bouarfa decision, you can't even ask a judge to review it. Let me explain what this case really means, the very limited chances you have to fight a revocation, and how to protect your family's immigration plan moving forward. Hi, I'm Zyra Solano, immigration attorney and founder of Solano Immigration Law Firm. In December of 2024, the United States Supreme Court issued a unanimous decision in Bouarfa versus Mayorkas that dramatically changed how visa revocations are handled. In plain terms, if USCIS revokes an already approved I-130 visa petition, you can no longer challenge that decision in federal court. What the Supreme Court actually decided. This case involved Amina Bouarfa, a U.S. citizen who filed an I-130 petition for her husband. It was approved, but later revoked by USCIS under allegations that her husband had previously entered into a sham marriage. The government cited 8 U.S.C. Section 1154C, which bars visa approval for anyone who previously committed marriage fraud. Bouarfa tried to challenge the revocation in federal court, but the Supreme Court said, nope, you can't. Visa revocations are discretionary decisions made by the Department of Homeland Security, and federal courts have no power to review them. Justice Ketanji Brown Jackson wrote the opinion interpreting the phrase, quote, may at any time for what he deems to be good and sufficient cause, end quote, as clear evidence of discretionary power. Discretionary versus non-discretionary. Why it matters. There are two kinds of immigration decisions. Non-discretionary. These are decisions that are based on clear requirements, basically if you're eligible or not. Discretionary means that these decisions are based on judgment calls by immigration officers. You may or may not meet the requirements. The court ruled that revoking petitions is discretionary. This means that even if USCIS is wrong, even if you have strong evidence, even if their reasoning is flawed, you cannot ask a federal judge to step in. Before this decision, some federal courts did allow challenges. That's over now. Let's say your spouse's I-130 is approved. You start preparing to move, then USCIS sends a revocation notice claiming fraud or ineligibility. Before December 2024, you could sometimes sue in federal court. But after Bouarfa, you're stuck. No court, no appeal, and that's terrifying for thousands of families. USCIS doesn't make legal calls. They make factual findings. If they say your marriage is fake, if they say your employer's offer isn't legitimate, if they say you committed fraud, those are facts, not opinions. Now, those factual findings can't be reviewed by any court. This raises real concerns. What happens when USCIS gets it wrong? They have immense power and now very little oversight. These are the cases that can be affected. I-130 family petitions due to revocations over alleged fraud. I-140 employment petitions revoked for wages, job duty, or legitimacy issues. Other grounds, including criminal records or inadmissibility findings, all of these can now be revoked without court review. This is what you can still do. Federal courts are off the table, but few options still remain. When you receive a notice of intent to revoke, you typically have 30 days to respond. This is your only chance to submit evidence and legal arguments. Do not delay. Do not DIY this. Do not try to do it yourself. This can make or break your case. Another option is a motion to reopen or reconsider with USCIS. You can file it with them after the revocation. But if you do, you must meet very strict deadlines and show new evidence or errors in law. You can also refile the petition. This is possible in some cases, but not if the revocation involves fraud or misrepresentation. You can also appeal to the Administrative Appeals Office, AAO. They review some revocations, but they also give heavy deference to USCIS. They rarely overturned unless there's a clear legal or factual error. Here are some practical steps you can take to protect your case. First of all, anticipate problems early. Address any potential red flags before you file. Document everything. Keep strong records of your relationship, finances, employment, and a timeline. Respond immediately to notices of intent to revoke or request for evidence, and treat every request like a potential denial. Get legal help early. With fewer review options, mistakes are now getting harder and harder to fix. The courts are backing away. This Supreme Court ruling is part of a growing trend. Less court review, more agency power, higher risks for immigrants. We've seen this in other areas too, like asylum and removal defense. This shift means one thing. You must get it right the first time. There may not be a second chance. If you have an approved petition, stay vigilant. If you are about to file, work with an experienced immigration attorney. If you receive the revocation notice, act immediately within the deadlines and seek legal counsel. In my next video, How to Protect Your Green Card in the Trump administration, we'll talk about what documents to keep, what not to post online, and how to avoid small mistakes that can cost you your status. Make sure you follow and subscribe because the law is changing fast and staying informed is your best defense.